Hello, my name is Sebastian Rodríguez, and I'm gonna talk to you about the case between Southern Pacific Company and the Arizona state. Here are the facts. In 1940, the state of Arizona brought suit in the Arizona Supreme Court against the appellant, the South Pacific Company, to recover the statutory penalties for operating within the state two interstate trains. One, a passenger train of more than 14 cars, and one freight train of more than 70 cars. The appellant answered admittingly the train operations, but defended on the ground that the state statute offends against the Commerce Clause and Due Process Clause of the 14th Amendment and conflicts with the federal legislation. The legal issue here is whether the Congress has, by legislative amendment, restricted the power of the states to regulate the full length of the interstate trains as a safety measure, and if not, whatever the statute contravenes the Commerce Clause of the Federal Constitution. Considerations. The court says that although the Commerce Clause conferred on the national government power to regulate commerce, its possession of power do not exclude all states' power regulations. It has been recognized that in the absence of conflict legislation by Congress, there is a residuum of power on the state to make laws, govern matters of local consent, which nevertheless, in some measure, affect interstate commerce or even, to some extent, regulate it. In this case in particular, the findings shows that the operation of long trains, that is, trains of more than 14 passengers and more than 70 cars, is a standard practice over the main lines of railroads in the United States, and that if the length of trains is to be regulated at all, national uniformity in the regulation adopted, such as Congress, can be prescribed practically indispensable to operation of an efficient and economical national railway system. On many other railroads, passengers are indispensable to the operation of an efficient economical system. Trains of more than 14 cars can be found, and freight trains of more than 70 cars are operated. And in some systems, freight cars are ranging from 125 to 160 cars length. Outside of Arizona, where the length of trains is not restricted, an appellant runs about the proportion of long trains. In 1939, on the comparable route for the South Pacific through Utah and Nevada, from 66 to 85% of the freight trains were over 70 cars in length, and over 43% in passenger trains, including more than 14 passenger cars. These assessments may make the court to deduce this. If one state may regulate train lengths, so many others will do, and they will need to not prescribe the same maximum limitation. The practical effect of such regulation is to control train operation beyond boundaries of a state, exciting it because of the necessity of breaking up the resembling long trains the near terminal point before entering and after leaving the regulated state. The serious independent to the free flow of commerce by local regulation of train lengths, the practical necessity that such regulation, if any, must be prescribed by a single body having a nationwide authority are apparent. The court concluded that the state goes too far on his regulations. of the train links, immediately obstructed to interstate train operation and having a serious adverse effect on transportation efficiency and economy, passes beyond what is plainly essential for safety, since it does not appear that it will lessen rather than increase the danger of accident. Its attempt regulation of operation of interstate trains cannot be established nationwide. Controls such as essential to the maintenance of an efficient transportation system, which only Congress alone can prescribe, the state interest cannot be preserved at the expense of the national interest by enchantment with regulate interstate train lengths without securing such control, which is a matter of national concern to the interest of the state, here asserted is subordinates.